Imagine walking into a supermarket and discovering that one organisation had secured exclusive rights over the word Basmati. Not over a particular logo, not over a distinctive brand name, over the word Basmati itself. For Indian producers, Basmati is far more than an ordinary product description. It represents rice grown in a particular region using recognised varieties and standards with qualities linked to geography, climate and tradition. But there is a rather significant complication. Basmati rice is also grown in Pakistan, and Australian consumers generally understand Basmati to be a type of rice, not necessarily a certification that the rice has been approved by an Indian authority. That distinction sits at the heart of a recent federal court decision about whether Basmati could be registered in Australia as a certification trademark. It is also a fascinating contrast with the Pisco decision we discussed in an earlier episode, episode 31, where Peru successfully established that Pisco could be registered as a certification trademark, even though Chile also produces and sells a spirit called Pisco. So, why did Pisco succeed while Basmati failed? The answer tells us a great deal about geographical indications, certification marks, and the importance of what Australian consumers actually understand a name to mean. Welcome back to Elise Explains IP, where we make intellectual property practical for business owners, founders, and advisors. I'm your host, Elise Dijkstra, IP nerd, commercial lawyer, and trademarks attorney. Today, we are looking at Agricultural and Processed Food Products Export Development Authority, Ministry of Commerce and Industry, Government of India, and Registrar of Trademarks. A federal court decision delivered on the 11th of August 2026. Thankfully, for the rest of this episode, I am going to refer to the Indian authority by its much more manageable name and acronym, APEDA. The application for Basmati was made by APEDA, which is an Indian government authority that represents the interests of Indian producers and stakeholders in Basmati rice. It administers the standards and provides a licensing system for the export of certified Indian Basmati rice, including rice exported to Australia. It applied to register 2 certification trademarks in Australia. The first was for the single word Basmati, all on its own, and the second was a device mark that incorporated the word Basmati. A certification trademark is different from an ordinary trademark. An ordinary trademark identifies the commercial source of the goods or services. It tells customers, in effect, this product comes from this particular business or manufacturer. A certification trademark tells customers that goods or services meet a particular standard. That standard might relate to quality, ingredients, manufacturing methods, geographic origin, or some other important characteristic. Examples might include marks certifying that a product is Australian-made, organic, environmentally responsible, or produced in a particular region. The critical function is still one of distinction and identity. The certification mark must distinguish goods that have been certified by the relevant certifying body from the goods that have not. In this case, APEDA needed to show that Basmati was capable of distinguishing rice certified under its Indian system from rice that had not been certified under that system. The Trademarks Office was not persuaded. Following a hearing in front of the delegate, they accepted the device mark incorporating the word Basmati, but refused the word registration Basmati on its own. The delegate considered that other traders had a legitimate need to use the word Basmati to describe their rice, including producers whose rice was not certified by APEDA. APEDA appealed to the federal court. And the question was, what does Basmati mean to an Australian consumer? The appeal required the court to consider the ordinary signification of Basmati. That is legal language for a fairly practical question. What would the ordinary Australian person who buys, eats or trades in rice understand the word Basmati to mean? APEDA argued that Basmati was not a place name, an ordinary English word, or a simple description like white rice, brown rice or long grain rice. It also argued that Australian consumers strongly associated Basmati with India. There was certainly substantial evidence of Indian Basmati rice being sold in Australia. More than 306,000 metric tonnes had been exported from India to Australia between 1988 and 2019, with a value of approximately $380 million US. That is a lot of rice. But the problem for APEDA was that the substantial quantities of Basmati rice from Pakistan were also sold here. The evidence included Pakistani Basmati products sold through major Australian supermarkets. In 1 year alone, Coles sold 500,000 1 kilogram packets of one Pakistani Basmati product. The other Pakistani products also recorded substantial sales. The packaging identified whether the rice came from India or Pakistan, as required by Australia's country of origin labelling rules. There was also evidence from cookbooks, dictionaries, and food reference texts. Some referred to Basmati as an Indian rice. Others described it as an aromatic rice from Pakistan and northern India. Historically, Australian retail material similarly showed Basmati rice from both countries being offered for sale. The evidence, therefore, did not support the proposition that Basmati meant rice from India alone. It suggested that Australian consumers understood Basmati to be a particular type of aromatic long-grain rice grown in both India and Pakistan. APEDA also relied on survey evidence. Around 71% of respondents associated the word Basmati with rice. But when asked where Basmati rice came from, only around 30% said India alone. More than half did not identify any place at all. Approximately 11% referred to India and somewhere else, while Pakistan was also identified by some respondents. The court considered that the survey evidence did not establish the strong, exclusive association with India that APEDA needed. More importantly, even an association between Basmati and India would not necessarily have been enough. There is a difference between consumers associating a product with a country and consumers understanding a word to perform a certification function. A person might think of India when they hear Basmati, but that does not mean that they understand Basmati to mean this rice has been inspected and certified by APEDA under its particular Indian certification system. And that distinction proved critical. The court accepted that Basmati is a specific product with particular characteristics and a connection to a defined growing area. The rice is associated with the Indo-Gangetic plains below the Himalayan foothills. Its recognised characteristics include long, slender grains, a nutty aroma, a soft texture, and a delicate curvature. The difficulty was that the growing area extends across parts of both India and Pakistan. APEDA's certification scheme covers Indian Basmati. It does not certify Pakistani Basmati. The word Basmati, therefore, described both rice certified by APEDA and rice that could legitimately be described as Basmati, but had not been certified by APEDA. This means that the word does not distinguish APEDA certified rice from any other Basmati rice. Pakistani producers have a legitimate commercial need to use the word as well. Their use is not an attempt to imitate Indian producers or to take unfair advantage of APEDA's reputation or even the reputation of Basmati. It simply describes the product they were actually selling. The court concluded that Basmati was not inherently adapted to distinguish APEDA certified rice, nor had it acquired that capacity through use, sales, reputation, or other circumstances. The fact that Basmati was recognised as a geographical indication in India and in other jurisdictions did not, by itself, satisfy Australia's requirements for registering a certification trademark. International recognition does not automatically translate into an Australian registration. So what about some conditions protecting the Pakistani producers? APEDA tried to address the problem through the proposed rules governing the certification mark. Those rules would require approved products to display Product of India prominently on their packaging. The packaging would also state that Basmati was a certification trademark of APEDA. APEDA also proposed a condition making it clear that registration would not prevent legitimate use of Basmati for rice originating in Pakistan. On one level, that sounds like a commercially sensible compromise. Indian producers could identify APEDA certified rice, while Pakistani producers could continue using Basmati for their own products. But the court's concern was more fundamental. The application was for Basmati itself. The court said that the mark needed to be capable of distinguishing the certified goods. It could not rely on any accompanying statements, certification rules, or conditions to give the word a distinguishing quality that it did not otherwise possess. Even if the packaging said product of India and expressly referred to the APEDA certification scheme, that would not change what Australian consumers understood the word Basmati itself to mean. They would still understand it as the name of a type of rice grown in India and Pakistan. The court was not prepared to take out its red pen and rewrite the conditions in an attempt to make an otherwise unregisterable mark registrable, and so the appeal was dismissed. So why did Pisco succeed? So this is where the decision becomes particularly interesting. Only a short time before the Basmati judgment, the federal court decided that in Republic of Peru and Register of Trademarks, Peru had sought to register Pisco as a certification trademark for alcoholic beverages excluding beer. Now, Chile also produces a spirit called Pisco and has sold Chilean Pisco in Australia. On the surface, it might seem quite similar to Basmati being produced in both India and Pakistan. But the court reached the exact opposite conclusion in the Pisco case. Pisco was accepted as registrable. Importantly, the Basmati court said that the two decisions were not inconsistent. The same legal principles were applied in both cases. The difference in the cases lay in the evidence and in what Australian consumers understood the respective words to mean. Pisco is the name of a town and region on Peru's southern coast, close to the vineyards where the grapes used to make the spirit are grown. The evidence in that case demonstrated a history of Pisco production in that region extending for more than 450 years. The evidence also showed that Peruvian Pisco had a much more substantial presence in Australia than the Chilean Pisco. Taken as a whole, the court, in the Pisco case, considered it more likely than not that an ordinary Australian consumer would understand Pisco as indicating a location or region in Peru from which the beverage originated, not simply as a general name for spirits produced in either Peru or Chile. Basmati was different. Basmati is not the name of one particular place. It is the name of a type of rice associated with a growing region spanning parts of 2 different countries. There is also substantial evidence of Pakistani Basmati being sold in Australia. In simple terms, an Australian consumer encountering Pisco was likely to understand the word as pointing towards Peru. An Australian consumer encountering Basmati was more likely to understand the word as identifying a type of rice, and that difference was decisive. The two cases demonstrate the fine line between a name that identifies a geographic origin and a name that identifies a category of product. Pisco was found on the evidence in that case to communicate geographic origin. Basmati communicated product type, even though the characteristics of that product were connected with a particular cross-border region. That is not to say that one product has more authentic history or a stronger cultural importance than the other. Trademark registration does not decide who has the most compelling historical narrative around the application. It asks whether the particular sign performs the distinguishing function required by Australian law. That question is answered from the perspective of Australian consumers and traders. There are several practical lessons here for businesses and industry bodies. First, protection in one country does not guarantee protection in another. A name may be registered as a geographical indication in its country of origin and recognised in multiple other jurisdictions. Australia will still apply its own legislation and examine how the name is understood in the Australian market. Second, sales and reputation are not enough on their own. APEDA established very substantial sales of Indian Basmati rice in Australia, but those sales did not prove that consumers understood Basmati as a badge of APEDA certification. A business must show more than a familiarity or association. It must show that the sign distinguishes its goods, or its certified goods, from those of others. Third, evidence needs to answer the right question. Survey evidence can be very valuable, but the survey needs to test the actual legal and commercial issue. Knowing that consumers associate Basmati with India is not the same as knowing that they rely on Basmati as an indication of certification by APEDA. Likewise, market evidence should not simply establish how much product has been sold. It should help demonstrate what the sign communicates to customers. Fourth, consider whether the word mark is doing too much of the work. APEDA did secure acceptance of a device mark incorporating Basmati, even though it could not register Basmati by itself. That is a useful reminder that a distinctive logo, emblem, or composite mark may provide a more realistic form of protection where the central word is geographic, descriptive, or commonly needed by other traders. A certification system may be commercially valuable, even if the product name itself cannot be monopolized. Finally, investigate competing legitimate uses before filing. If other producers have a genuine need to use the same word to describe their products, that will be a major obstacle. Conditions and disclaimers may not cure a problem that goes to the very inherent meaning of the mark itself. The Pisco and Basmati decisions are not really a story of Peru winning and India losing. They show that geographical protection in Australia turns on evidence. What does the name mean to Australian consumers? Does it identify a place, a product category, or a particular certification system? Are competing uses minor and peripheral, or substantial and legitimate? And does the proposed mark genuinely distinguish certified products from products that have not been certified? For Pisco, the evidence pointed towards a Peruvian geographic origin. For Basmati, the evidence pointed towards a type of rice grown in both India and Pakistan. The history, quality, and reputation of Basmati were not in doubt. The problem was that Basmati did not tell Australian consumers which rice had been certified by APEDA. And that is the practical lesson for any businesses or industry group trying to protect a name associated with a region, tradition, or a production method. Authenticity matters, but authenticity and registrability are not the same thing. Before investing in an application, you need to understand not only the history of the name, but also how it is being used by competitors and what it means to the people who will encounter it in the Australian marketplace. If you are developing a certification scheme, protecting a regional product, or trying to determine whether a valuable name can be registered, it is worth getting some strategic advice before filing. And you can book an IP strategy call with me via my website at elisesteekstra.com, or try out my IP audit tool so that you can see where you have gaps in your IP strategy. Thanks for listening to Elise Explains IP. If you found this episode useful, please follow the podcast and share it with someone who enjoys a good intellectual property dispute served with a side of rice, or perhaps washed down with Pisco sour. Until next time. Thanks for spending time with me on Elise Explains IP. If you picked up something useful, hit follow, subscribe, leave us a review, or send it to a founder friend who could use this information. And remember, this is general information, not legal advice. If you do want help with your IP, you can book a strategy call with me at any time via my website. The link's in the description. So until next time, own your own ideas.